You're muted, Ms. Marks.
Sorry. Good morning, Your Honor. Can you hear me now?
I can, thank you.
Okay. The debtors have filed a motion under Rule 9019 to settle an underlying litigation brought against certain debtor entities and other co-defendants by the Hempel plaintiffs. The settlement is for $3 million. It will come out of an escrow fund that is not property estate according to the debtors. The only objector to this motion is the Acklar plaintiffs, represented by Mr. Haviland. We've discussed with Mr. Haviland and both parties agree that we can forego oral argument and rest on the papers, given that this is a legal rather than a factual issue. We are available to answer any questions that the court may have.
Now, I have read the papers and I'm satisfied that the settlement is appropriate and that it is in the best interest of the debtors and the debtors' estates and all of the constituencies. And I think the objection was unfounded. So I will overrule the objection and I will enter that order.
Thank you.
Anything else?
Thank you, Your Honor. We'll upload the order. I think that takes us to our next matter on the agenda, which is agenda item number 15, which is the UCC's 2004 motion. The hearing on the motion itself is adjourned, but the UCC wanted to make some statements on the record at the hearing.
All right. Who's speaking for the UCC? Oh, go ahead, Ms. Beckhart.
Thank you, Your Honor. As noted in the amended agenda, the hearing on this matter has been.
I'm having difficulty hearing you, Ms. Beckhart.
Can you hear me now? I'll be a little louder.
It's better? Very faint. I'm not sure. It sounds like there's something covering your microphone or something.
Oh.
Huh. Might have to speak up a little bit. Let me turn up my volume over here too.
Okay. I'll try to enunciate.
It's really a bad connection. I'm not sure what the issue is, but.
Can you hear me better now?
I can hear you. It's kind of gravelly and distant, but let's see if we can get through it.
Okay, let me just see if I can adjust something on my end.
Well, now I can't hear you at all. I'm not sure what's going on.
Can you hear me better now?
A little bit, yeah.
As noted in the amended agenda and as Mr. Merchant indicated, the hearing on this matter has been continued to May 12th, and we did agree with the debtors that we would make a statement.
Now I can't hear. It's fading in and out. Maybe you need to. Maybe if you hung up and dialed back in again, maybe that would be helpful.
I think that's changed about my
sometimes
system.
Sometimes it's just a bad internet connection.
I'm sorry. Should I go out of the room and come back in?
Why don't we try that and see if that helps?
Okay, I'll leave and try to come back in.
All right, thank you.
Can you hear me?
I can hear. There you are. Okay, go ahead. Let's try this.
Okay. Your Honor, as noted on the amended agenda, and as Mr. Merchant indicated, the hearing on this matter has been continued to May 12th. And we did agree with the debtors that we would make a statement regarding the 2004 motion during this morning's proceedings. That statement is intended to contribute to the record some important details regarding the agreement.
No, I'm sorry, Ms. Beckhart, but you're fading out again. There seems to be some kind of interference. Is everybody else muted? Let's try to mute everybody and then Ms. Beckhart unmute. Getting some kind of feedback. All right, try it now, Ms. Beckhart. Let's see if that works.
Okay. This statement from the UCC this morning is intended to contribute to the record some important details regarding the agreement in principle that the parties have.
It's just not working, Ms. Becker. I'm sorry. Is there something else? Are you dialed in through your computer or your telephone?
Through my computer. I can try my phone.
Let's try the phone. Maybe that'll work better.
All right.
All I heard was important and record, so I want to make sure it gets onto the record. Otherwise, we're going to have a garbled record.
You are in the now.
How's that?
That's much better.
Okay, fantastic. Sorry for the inconvenience on that, Your Honor. I don't know what's wrong with your system. The statement from the UCC this morning is intended to contribute to the record some important details regarding the agreement in principle that the parties have reached to resolve disputes related to our request for 2004 release, the specific terms of which are subject to a process of documentation that is currently underway. And in full disclosure, Your Honor, we did agree with the debtors on the precise language that would be used in articulating the important features of the settlement this morning. And so I'm going to read that language into the record. And I wish that I had some theatrical talent that could make this a more exciting recitation, but I'm afraid the best I can do here is to try to be brief and audible. In settlement of the UCC's motion under Rule 2004, the parties have agreed to the following terms. The UCC's first and second informal requests to the debtors are converted to formal requests under Rule 2004 by consent of the parties. With regard to document production, those fall into four categories. First, the debtors have agreed to continue to produce non-email documents, including those requested by the UCC's counsel and financial advisors, subject to the debtors' right to object to the UCC's document request. But these documents will continue to be produced on a rolling basis pursuant to the negotiations of the parties. Second, the debtors have agreed to reproduce to the UCC as soon as possible, but no later than this week, certain emails from document productions made in other litigations prior to the bankruptcy related to AXAR and other non-opioid litigations. The UCC has agreed to apply keyword terms and custodial and date limiters to search for documents related to its investigation. The UCC has committed that it will not review entire reproductions in whole. Parties have agreed that they will meet and confer regarding custodian, search terms, and timeframes that are not covered by the reproduction. Third, regarding new email searches and productions, the parties have agreed that the debtors will review 250,000 emails based on search parameters provided by the UCC and produce documents found to be responsive to the UCC's request from those 250,000 emails. The debtors have committed to using their best efforts to completing these productions by the end of June and to making rolling productions of these emails. The debtors have further committed to review a portion of those emails responsive to the UCC's priority request, which primarily relates to the pre-petition exchange transactions and mallinckrodt restructuring efforts belonging to 6 custodians, including Brian Reason, Stephen Welsh, John Einwalter, Kathleen Schaefer, Daniel Special, and Ian Watkins, and to produce responsive documents by April 30th on a rolling basis. The debtors have already produced a portion of those priority documents to the UCC on April 22nd. Regarding this 250,000 document review tab, the UCC reserves its rights to request additional email documents beyond what is sought in the first and second document requests, but the UCC has committed to 1, ensuring any requests are narrowly tailored as possible, and 2, that such requests would not increase the overall 250,000 document review tab. The debtors have reserved all rights to object to such additional discovery. Parties have also agreed that discovery regarding discrete contested matters that may arise in these cases will not be subject to the document review tab, excluding plan confirmation to the extent that is considered a contested matter. CAP will apply to case milestones such as discovery related to the plan and confirmation. And fourth, the debtors have agreed to produce to the UCC on a timely basis all documents it produces to the OCC in response to that committee's document request. With regard to productions that will be completed on a rolling basis, the parties will negotiate in good faith interim deadline targets in order to ensure documents are produced on a periodic and manageable timetable. Regarding depositions, the debtors have agreed to produce appropriate witnesses for deposition on a timely basis without the need to first obtain Rule 2004 authority. Debtors reserve the right to object to any given deposition request or number of depositions requested. As the OCC did in connection with resolving its Rule 2004 motion with debtors, the UCC agrees to coordinate with the OCC in discovery to the extent the committees can reasonably do so. Finally, with regard to third-party discovery, while the debtors have reserved their right to object to the UCC's request for third-party discovery, they have committed to limiting their objections to the greatest extent possible so the UCC can obtain the discovery it needs from third parties to complete its investigation. There are additional details regarding these points that the parties hope to nail down and hammer out and memorialize in a stipulation as soon as possible, but no later than May 12, 2021. Your Honor, thank you for your patience in allowing the record to receive these terms as I have described them. That concludes our statement on the motion for Rule 2004.
Okay. Thank you, Ms. Becker. Anything else? Okay, so just so I understand, there's going to be then a stipulation submitted with regard to the 2004 motion. Is that my understanding?
Yes, Your Honor, that is the goal. We've continued the hearing on the 2004 to the next omnibus on May 12th, but in the interim, we will be working on a stipulation with the hope of submitting it to chambers.
Okay, excellent. All right, anything else for today, Mr. Merchant?
Yes, Your Honor. We have two more matters left that require discussion on today's agenda. The next is agenda item number 17, which is the debtor's motion for a protective order. My colleague, Mr. Stern, will be addressing that matter with the court.
Okay, Mr. Stern.
Good morning, Your Honor. May it please the court, Bob Stern from Richards, Layton and Finger on behalf of the debtors. Can Your Honor hear me okay?
I can, thank you.
Your Honor, we are here on the debtor's unopposed motion for protective order. That protective order is the product of many months of negotiations, sometimes friendly, sometimes contentious among the debtors and their stakeholders. But at the end of the day, everyone was negotiating in good faith and seeking to protect their interests, and we were able to agree upon a form of protective order. Your Honor, this protective order checks all the boxes. Among other things, it defines confidential and highly confidential information. It identifies who can see that information. It provides processes for the use of confidential information in discovery, for filing confidential information under seal, for using confidential information at hearings, and for disputing confidentiality designations. There's a number of other bells and whistles that we don't need to go through, but which we typically see in protective orders entered by this court, such as providing protection for privileged information. The debtors, Your Honor, have been producing and will continue to produce substantial discovery to both committees, among other folks. That discovery includes a significant amount of the debtor's confidential information, including competitively sensitive business information. And so the debtors need this protective order in place now to ensure protection of their confidential information. For these reasons, Your Honor, the debtors would respectfully request that the court enter the corrected revised proposed protective order that we filed this morning, which corrected two typos. Does the court have any questions of me?
I don't. I did see the proposed revised protective order right before the hearing. It wasn't a red line. Were there any significant changes?
There was a red line, and actually we tried to keep it brief. Maybe we made it too obvious. There was a single page on which the two typos were corrected, and we attached only that single page.
Let me see here. Okay, I see it.
Perhaps
and a very small change.
Against us.
All right. Does anyone else wish to be heard? All right. I'm satisfied. I'm sorry.
Sorry, Your Honor. This is Walter Goldsby. I want to be heard on another matter when you have a moment.
All right. Anybody want to be heard on the protective order? All right. I'm satisfied that relief is appropriate. I will enter the order.
Thank you, Your Honor. I believe it still needs to be uploaded, and we will do so.
All right. Thank you. All right. Mr. Goldsberry.
Morning, Your Honor. Walter Goolsbury on behalf of the Actar plaintiffs. I just wanted to circle back on agenda item number 2, the motion to disqualify filed regarding Arnold and Porter. The supplemental declaration of Michael Bernstein resolved our certain of the issues raised in our motion regarding disclosures at this time. What I wanted to make clear for the record was us, Actar plaintiffs, not proceeding with that motion is without prejudice to any issues that are on appeal or otherwise at this time. So I just wanted to make the record clear on that.
All right. Thank you, Mr. Goldberg. Mr. Merchant, one more item on the agenda.
Yes, that's correct, Your Honor. The final item on the agenda is agenda item number 19. It was listed as the scheduling conference in connection with that adversary proceeding. Mr. Murtaugh is on and will address that on behalf of the debtors.
Okay, Mr. Murtaugh.
Good morning, Your Honor. Hugh Murtaugh from Latham & Watkins on behalf of the debtors. Can you hear me okay?
We can, thank you.
Your Honor, a few updates in respect of the adversary proceeding. First, defendants Mr. Parker and the Buxton Helmsley Group did retain counsel a little more than 2 weeks ago, Ms. Julia Klein of Klein LLC, and the debtors have been working with and discussing with her since that time. Second, as a result of those discussions, the debtors believe that the parties have agreement on the substance of an injunction that could be entered without objection or the need for a hearing. However, defendants have insisted that that injunction be presented to the court as a stipulation that could be so ordered rather than as a simple order of the court. And just to give status, that does not work for the debtors. Defendants' discovery productions to date have disclosed a number of communications and a number of plans discussed in those communications that the debtors believe violate the TRO and demonstrate the defendant's propensity to seek to evade the injunctive restrictions. So it's very important to the debtors that any relief that is entered is in the form of a simple order that can clearly be enforced by this court through, among other things, contempt proceedings, rather than as what may be argued to be an agreement that has less protection. Our understanding is that as of this morning, defendants are not prepared to proceed on that basis. And if they are not, then we will proceed to the hearing. Third, with respect to the hearing, that's scheduled for May 5th. Mr. Parker's deposition, both as in his individual capacity and as representative for the Buxton Helmsley Group, is scheduled to take place tomorrow, April 28th. We have identified to Ms. Klein a number of deficiencies in defendants' existing productions, and we have requested that they be cured through supplemental productions. To date, we have not received any supplemental production. So it's becoming a real possibility that we will need to hold open Mr. Parker's deposition in order to examine him with the benefit of those documents when they are produced. And if that comes to pass, then we may need to come back to Your Honor to discuss further adjourning the hearing and extending the TRO. So those are the updates as we have them, Your Honor. Of course, we would hope to resolve them among the parties and not further burden the court, but that is where we are this morning.
All right, Ms. Klein, do you want to be heard on the issues?
Yes, good morning, Your Honor. Thank you for your time this morning. I agree with Mr. Murtaugh that we have an agreement in principle. Initially, I had suggested that we stipulate to a protective order since it is really a stipulation, and then I was informed there were some issues about enforcement. So I'm no longer wedded necessarily to a stipulation. However, I object to the form of order, and there really has been no good faith effort on behalf of the debtors to work with me on the form of order. So just to be clear, we agree word by word on what the injunction should be. We no longer insist on making changes. So we agree word to word on what the injunction should be. However, there are a lot of findings of fact and conclusions of law that I see in the order that I believe simply are not appropriate because there has been no evidence presented. This is a consent order, and the court hasn't weighed any evidence. So I don't think that the court is in a position to make some of those findings and conclusions of law. So we are at a position where the debtors are saying my form of order, or we're going to go ahead with the deposition and discovery and an evidentiary hearing, which to me, I don't think that's a very reasonable position to take. So I don't know how this can be solved. Maybe we can submit competing orders, given that the debtors are not willing to work with their own form of order. The only thing that they have removed was a injunction against me personally, which I thought was nice, but a little bit more give or take would be nice. So I don't think that there is a controversy before the court at all, given that my clients, both the Boxer Helmsley Group and Alexander Parker agree verbatim to the injunction itself. It's just all that extraneous matter that shouldn't be in there. That seems to be a holdup in getting this resolved.
All right. Well, I do think if it's going to be an injunction, you can't really have a stipulated protective order. I don't think that does the job. So I think it does have to be an order of the court. But I do have an issue with, if you're going to ask me, Mr. Murtaugh, to enter an order that includes findings of fact that are not before the court, I'm not going to be able to do that unless you present the evidence.
Your Honor, to be clear, there are no findings of fact in the proposed order. So maybe we just have a misunderstanding. It sounds like there's enough common ground that I'd be optimistic we can find a resolution among the parties.
Okay, that sounds good. Then I'll leave it to the parties to try to get it resolved. And when did we push this to now? What's the date?
It's scheduled for May 5th, Your Honor.
Let me pull up my calendar here. Okay, that's not too far away. All right, let me see. Do we have... Hold on 1 second here. Okay, I have that whole day blocked off just in case. So if you do reach an agreement, let me know sooner rather than later so that I can open up that day on my calendar. I'd appreciate it, given how busy the court is right now.
Understood, Your Honor.
All right.
Thank you, Your Honor.
Thank you. Anything else for today, Ms. Merchant?
I believe that's all we have for today, Your Honor. Thank you.
All right. Thank you all very much. Appreciate getting these things resolved in a quick fashion. So but if we can reduce the size of the agenda, Mr. Merchant, that would be. All right. Thank you all. We're adjourned.
You're welcome.
Thank you, Your Honor.